Eugene Thompson, personal representative versus Hillside Building, Conduent Business Services, and the estate of Lisa Margaret Eugenie Thompson. Counsel for appellant.
May it please the court, counsel. My name is James Wachewski, and I'm here on behalf of the appellant, the estate of Lisa Margaret Thompson. My client is Mr. Eugene Thompson, her father, who was appointed a personal representative in the case. This is another summary judgment case, I guess not coincidentally, but we got 3 in a row. And in this particular case, we are alleging that there were errors by the trial court in entering summary judgment vis-a-vis both of the defendants. So we have a case where there are 2 defendants, the landlord of the property, and then we also have the employer. Now this...
Would you like to reserve any rebuttal
Oh, yes,
time?
I forgot. I would like to reserve 5 minutes for rebuttal. Thank you,
Good,
Judge.
thank you.
Okay, so the case against Conduent, the employer, of course, maybe touches briefly upon an issue that has been of a huge contention for this court last year. You guys had, I guess, a lot of debate on the case that was called, is it Norman Insurance Company versus Boyard?
Rings a bell, yes.
Yes, and I actually looked at the opinion and I saw that I think Judge Norby is on one side of the issue, Judge Bilbrey is on the other side, and I think Mr. Osteros, Judge, you were in the middle. So obviously, the issue of who should be responsible when something horrible like what happens in this case is very important. The issue of liability, and in this case, we have several theories of liability that we raise in the complaint. We have the issue of the fact that there was an employer-employee relationship. And in this case, we had the option of going the workers' compensation route. We actually did pursue a workers' compensation claim against one of the defendants, and it was denied. And then we had the option of deciding to pursue that on the workers' compensation arena, or to then file a common law case, because in the state of Florida, we also have common law causes of action. So when you have an employer-employee situation, if the employer denies workers' compensation benefits, then you can file a civil case, and you don't have the issue with the immunity provided by the workers' compensation statute. Now, this case, of course, is a little bit different than the one that made all this interesting arguments between all the judges in this court. But if it were a workers' compensation case, it would be interesting to see if the result would have been different, because here we have a person who was targeted, right? We have the ex-girlfriend and mother of the joint child of a felon who was being targeted. She was being harassed. She was being stalked. She was getting phone calls, and so now she was a potential victim of a crime. And unfortunately, domestic violence results in very serious crimes all the time. It's a very serious problem in our society, everywhere in the world, but including in the United States. Here in Tallahassee, just last week, if you all read the Democrat, there was another case of a woman who was murdered by her husband. The husband was suicidal. The police was able to calm him down. So this happens all the time. And
well,
unfortunately,
can I ask you, the best evidence it seems like you have of any kind of duty was Ms. Dawkins' testimony that she told Ms. Rowe before Ms. Thompson disappeared. She told Ms. Rowe that Dawkins had been kidnapped by her ex-boyfriend, right?
correct.
That's. Am I correct? That is the best evidence of any kind of duty that you have.
That was not the only theory that we were pursuing in the complaint, but on that angle, which is the angle that the defendant sought summary judgment on the fact that there was a superior knowledge by at least one of the defendants, and that created a duty to do something about it, that was the best evidence.
And Ms. Rowe disputed that, but I agree with you that for summary judgment purposes, we got to assume that Dawkins did tell Rowe what Dawkins testified she told Rowe.
Correct.
Right? So assuming that happened, what does that put Rowe on notice of? What is she supposed to do when it's not on the property, it's not at work, it's not a co-employee? Why does that provide some duty from Rowe, an employee of Conduit, to do anything?
Sure. There are many, many reasons. In fact, The state of Florida, most of its agencies, probably all of its agencies, have what is called a domestic violence or partner violence policy in their human resources procedures. They want to get that information because they understand that when there's somebody who's potentially a target of a crime, that crime can come to the location of the person's job. Why? Because the abuser, they know that if the victim is hiding from them, one place that they have to go to earn a living is their place of employment.
And I'm with you there. If
Yeah.
Dawkins was coming into work and working at the conduit site, perhaps the analysis would be different. But Dawkins was working at home remotely, and she testified that she told Rowe that she was going to come in and return her computers after they finally catch Gibson, right?
Sure.
So I understand what you're saying, but that doesn't seem to create any duty when Dawkins is off-site, right?
Okay, so a couple of things about that. I probably should finish answering the previous
Sure,
question.
sure, and I'm sorry. to
And,
interrupt you.
and I'm sorry, Judge, but bottom line is that actually the defendant Conduit testified, Ms. Rowe testified, that there actually was a policy in place, and that what her job was to then report this issue up to corporate, and then corporate would do something about it. So it was something where she was supposed to pass that information along so that somebody else in corporate would analyze, okay, does this require us to do anything? Put additional security. Maybe just give a warning to the other employees. Hey, here, there might be somebody coming on the property looking for Ms. Dawkins. Be on the lookout, and if you see somebody loitering on the property, which there's evidence of that in this case, they might have reported that. And in fact, several of the people who testified said, well, if we knew about it, when we saw this suspicious guy walking around the property, we would have reported that. We have done something about it. But can you remind me, what was the follow-up question?
Sure.
I just already forgot it.
Well, the follow-up was Dawkins didn't work on site,
Yes.
right? She was remote at the time and only said that she was going to come back after Gibson, the assailant, was caught, right?
Right.
So why does that create any duty when Dawkins is an off-site employee?
Okay. I think that, first of all, the information that was given to Ms. Rowe was about something very serious, right? A very, very serious crime had just occurred against an employee, and this employee just reported that the person that was doing all of this was a felon, that obviously this was a very, very serious crime, could have resulted in her murder. She got lucky that the cousin showed up. So the thing is this. First of all, as far as the fact that she was working from home, right? Now, all of this was not very clearly fleshed out in the summary judgment order, first of all. But in any case, what is clear from that is this, that Mr. Reginald Gibson, the killer, may not have known where exactly Ms. Dawkins was going to be on Tuesday, Wednesday, Thursday. He knew where she worked because there's evidence that he dropped her off or picked her up from work multiple times before their breakup. And their breakup happened before, if you look at the record, they actually have it all set out in the statement of facts of the brief. The breakup between Dawkins and Reginald Gibson happened before she went to work off-site. Now, off-site doesn't necessarily mean at home, but in any way. The question is, from the perspective of Rowe, is she needs to inquire further. Once you have knowledge that one of your employees is being stalked, do you automatically assume, oh, but you're working from home, so that's not an issue? Or do you pause and maybe think about it some more, talk to security, talk to corporate, follow up on this issue to determine whether or not there's something here that could become a problem at the job site, which indeed is what happened, right? Reginald Gibson didn't know that she was not working at the site.
So the duty extends beyond the first victim to the whole job, to everybody who works for the employer, and not only the employer, but everyone who works in the whole building, that there's a duty that's
Absolutely.
created
Any
in the
invitees could be injured. Anybody who may, let's say that Reginald Gibson comes on the property, and actually the evidence was a little bit different. It was a little bit contradictory about whether or not she was going to come back for work. There's evidence on the record, including from Ms. Rowe herself, indicating that Ms. Dawkins told her that she was coming back to the work site to bring back the equipment or because there was an IT issue. And I think Ms. Dawkins actually testified that she did go back to the job site on Friday before they figured out that Reginald Gibson was the guilty person, before he had been caught. He was caught later that evening. So Friday evening on the 30th, I think it was, that's when he was finally caught. So she actually went back to the site even before Reginald was caught.
Is our analysis the same for both Conduit and Hillside?
It is partially the same in the sense of if we're going to go on this whole issue about a duty based on the superior knowledge that the tenant had, right? The business tenant, which is Conduit. Our argument with respect to Hillside is the following. Hillside, so let's use a magic wand and transform this beautiful building into Hillside. It's in a very nice area that is isolated. There's not a lot of crime. I understand all of that. Now, there's a lot of interesting things about this building. There's a lot of security on the inside. There are cameras inside. There's Sonatrol cars to enter the building. So maybe some of the activity that the defendants were doing for the U.S. Department of Labor raised some risks. That was an issue that we never got to because that was never raised on summary judgment. I never felt that I had to have our own security experts, which we did hire, but we never had to file that because we thought that was not an issue at the summary judgment. It was not raised by the summary judgment motions. They only addressed one theory from the complaint, so we addressed that theory that they raised. But got very little sleep, and I guess I lost my train of thought.
No, I was asking about Hillside. That's okay.
Yeah. So Hillside.
Hillside,
Yeah.
your brief says that they're deemed to have had the same notice that Conduit has. What case says that a landlord
Yes.
knows the same thing as a tenant knows?
The best case that I can tell you on that issue, I would say, is against Hillside would be U.S. Security Services versus Ramada Inn. And it talks about the fact that there's a non-delegable duty, and in that case, I think it was a security company that had been hired. There are several cases that talk about this issue, but the bottom line is you just look at the facts. The facts in this particular case, as far as Hillside go, is that it has a beautiful building, but it has zero presence there. They actually rely on the tenants for pretty much everything. The tenants, the evidence shows that the tenants actually communicate to Hillside, hey, the lights are broken. Hey, this is the season when you're supposed to turn the lights a little bit earlier or later. They rely 100% on their tenants to report issues. In their responses to discovery, they say, oh, we do assessments, we do assessments about whether additional security needs are needed. But then they also create a completely confusing situation because the lease between the parties indicates, well, we're not providing any kind of security guards. So in this particular case, it was, what the evidence shows is that, first of all, Ms. Dawkins had no knowledge whatsoever about how to contact Hillside if there was a security issue. She would only be able to contact, she only knew about her employer. So there's no signs on the property. Say, hey, if you have any security issues, any concerns, any potential threats to the building, contact this place. All they know is that the evidence shows is that Hillside has contact with the manager of Conduit, and then Conduit knows how to reach Hillside. But the employees don't know how to reach Hillside to report a problem like in this case. And it probably would have been better because I'm assuming that an employee has concerns about losing their job. If they're gonna have to report that they were dating a felon and now the felon is coming after them, they may have concerns about their job. But I mean, if Hillside, the landlord, had a person on site, had signs indicating to the tenants, their tenants, right? I mean, in a business lease, you have a corporation that is a tenant, but the people that actually go and spend 1/3 of their life in the building is the people who work for those businesses. So I think that there's a non-delegable duty to those employees who work at that site for those employers, and that there's really nothing, this was a shoddy landlord that basically did what I think there's several cases that talk about this concern, right? About the fact that, well, the liability is attached to having superior knowledge. In this case, there was superior knowledge by the tenant, but the landlord just hid its head under this made a hole, he descend and descend. We don't know anything about anything. And is that what we really want for landlords to do? I think that is one of the, because this is a common law state, and because the common law dictates that issues of duty are actually decided by the courts, considering all of the facts, the totality of the circumstances, and public policy. That is one of the public policy issues to address. Any other questions? If not, I will reserve the rest of the time for rebuttal.
Very good, thank
Thank
you. Counsel for Appellees.
Good morning, Your Honors. May it please the Court, Kimberly Berman of Marshall Dennehy on behalf of the Appellee Conduit Business Services LLC. Your Honors, this case is tragic. We agree with the plaintiff 100% on that. It was a tragic incident. There was a random act of violence, but it was not Conduit's fault. And to find otherwise, there would be broad ramifications based on the facts here that would extend employer liability where it shouldn't be. This court should affirm the final summary judgment in favor of Conduit for two reasons. One has to do with the duty, which we've been talking about, and two, which Mr. Wachowski didn't get into, but part of the argument had to do with a due process violation, and we will contend that there is no due process violation. The first argument as it relates to duty, I'm just gonna get right in there and address, I believe it was Judge Bilbrey who was asking about the evidence. You tried to get Mr. Wachowski to agree that the only evidence of notice was Dawkins' testimony. And why was that not enough? Well, that was not enough because if you look at the testimony from Ms. Dawkins, it was very vague. She did not provide any detail. She was not feared for her life. She did not call Ms. Rowe to explain to her to say, there's a problem, I have an ex-felon. She didn't mention any of that. That all came out afterwards. She didn't mention any detail. All it was is there was a kidnapping that occurred at her son's daycare. It was not a kidnapping that occurred at the actual premises. Now, the Admiral case discusses how an incident that occurs off the premises is not probative of foreseeability. So it's our position that this is not a foreseeable. We don't have the facts here that Ms. Wachowski has alleged in his complaint. That's not what the record evidence shows. There was
So
no.
there's a continuum of possible facts and duty triggers, you're saying, at something closer to, there's a bad guy out there who's on his way to the property.
But we didn't have that, Your Honor. We didn't have those facts. That's not what the call was. That's not what the testimony is. And even if we assume the testimony from Ms. Rowe, she didn't find out about it until after the fact, you assume Ms. Dawkins actually called in when she said it, that we're all looking at like a 5-day period. You have the abduction that occurred Monday or Tuesday of the week. She went back to the daycare to investigate with the cops. Then she called on that day, possibly, because it wasn't clear whether or not she called. And then the next day, the incident at the property occurred. The testimony wasn't that I fear that he's going to come after me. It was I'm going to return my work, my computer, and start to work from home eventually. Not at that moment. There was not enough information that was provided to Ms. Rowe to take the next steps to go ahead and protect all the employees as Ms. Wachowski is trying to accomplish here. It would be a very different situation if Ms. Dawkins had actually filed the restraining order, which she did. She put her place of employment, which she did, but that all occurred on Thursday when Mr. Dawkins was already out. There's a lot of assumptions that Mr. Dawkins, and in the allegations and in the argument, that Mr. Gibson knew that Ms. Dawkins had, pursued the cops about the incident that she had, about a domestic violence restraining order that had been entered against her. But that's assumptions. Those are all theories. And that's not what the evidence is. All these things happen after the fact. Ms. Rowe had no reason to know that there was any danger that was going to come to the property. And there were no prior similar incidents either. So part of the analysis and duty has to do with constructive and actual knowledge, and whether or not there were any prior similar incidents. There were none here. There was also nothing alleged to assert that Conduit created the risk or controlled the risk. A lot of the briefing below had to do with control in the parking lot. I'm not going to get too into that, but there's nothing here where Conduit actually created the risk. There is no argument that Conduit did something, the policies, procedures, this is stuff that would occur after if they had enough notice to have a concern that there is something happening with an employee and that they need to protect the employees, notify other employees. In
Well,
any
it
event.
seemed like appellant's counsel was arguing that there's some further duty to inquire. Was that an allegation below, or is there some duty?
That-
So when assuming the facts, and you agree with me that for summary judgment, we've got to assume that what Dawkins said that she told Roe happened like it happened, right?
Correct, only the testimony is that she didn't give her any details.
Well,
She
right,
didn't go
she
into
said
depth.
she said she was kidnapped, so that's what I'm asking. Is there any obligation, if I told my boss I'm kidnapped, is there some obligation to ask further about that? Does that create any duty, and is that even alleged here?
No, Your Honor, I don't believe that's alleged, but I don't believe also that it is going to create a duty. And that is the case of, if I can look for a moment, there was a case that is in the briefing that had to do with a sexual assault of a tenant. It was a landlord-tenant issue, and there was sexual assault that was committed by a co-tenant, and the court found that there was a duty to warn the other tenants that the predator actually lived in the community, but there wasn't a duty to investigate further as to the particular incident that occurred. So there's no duty to investigate further. I can look real quick to see which case that is. It's escaping me at the moment. But it was...
Well, it's okay, we can look through the brief.
Yeah,
and
sorry, my
find it.
handwriting is
It's
terrible.
not a problem. Can I ask you, there was some discussion and maybe some disagreement between Conduit and Hillside as to whether this is a simple negligence case or a premises liability case. Which one is it, and does that matter here?
I don't think it matters, Your Honor. I think it's a premise liability case because they're alleging that it has to do with a duty to protect the employees at the facility. We couldn't protect her after she was taken from the facility and killed at another location at the cousin's house. So I think it is a premise liability. I don't think the duty matters. I think there's a question of whether or not it's an active versus passive negligence. Here it's all passive negligence, which is what you have in a negligent security case. You have a situation where could we have hired a security guard? Could we have warned the employees? Could we have done something? But there's nothing that we did actively that caused the actual person to come onto our property. There's no allegation that the door wasn't working properly, so when he entered the facility, we breached our duty because our doors weren't working, the badge, the enter and exit, had it occurred inside. So there's no active negligence. It's actual passive negligence that's here. So, but I don't even think it matters because I think even if you look at the passive versus active, and then you also have to look at trespasser versus invitee, no one's disputing that Ms. Thompson wasn't an invitee. She was an employee. She had a right to be there on the property at the time. So that whole level of analysis, which would make a difference between an ordinary negligence case and a premise liability case, doesn't come into play.
So, I mean, certainly both Conduit and Hillside had some duty to Thompson then, since she's lawfully on the property, right? Is what's missing here foreseeability? Is that what we're talking about, that it wasn't foreseeable, or is it notice? Why was summary judgment appropriate here?
Both. Foreseeability, which is part of duty, because foreseeability could be both part of duty and part of causation. So the foreseeability as it relates to duty wasn't present. It's not foreseeable that this was going to occur. It's also a notice issue because we didn't have any notice because it's not probative, it's not foreseeable that something happened elsewhere on another property across town, has no notice, nothing actually happened on the premises to provide them notice. So it's a combination of the two. And it's not a matter of the employee relationship, because you're correct. You would have a duty to an employee, but you have to go further. When you're dealing with the acts of a third party and a criminal act, you have to have control over that person. We had no control over the person that showed up on the property. We had no control over Mr. Gibson, that he was going to come onto the property and abduct her from the parking lot and then take her somewhere else.
Does the environment matter? The context in which, whether there's high crime area, that things are always going down in the parking lot versus not?
Well, it could, Your Honor, and there was the affidavit that Hillside provided that this is not a high crime area. So we had no notice in advance that this is a high crime area that we'd had any reason. It's a commercial office space with lots of businesses operating, all different types of business in a very large facility. It's not a high crime, area. So that also, goes to the notice and goes to the foreseeability. If we were in a high crime area, if this was a bar, a lot of the cases have to deal with bars and taverns and areas where there could be some rowdiness that occurs after, people leave intoxicated in a bar and they have a duty. We don't have that here. It's a very quiet, general employment area. So we don't have the same level of duty. I see I'm almost approaching my time, and I need to be splitting my time with Hillside. So if there are no further questions, I request that Your Honors affirm the sound final summary judgment in favor of Conduit.
Thank you.
May it please the court, Cody Short with the Pennington firm. I've also got Jeffrey Place, my associate, and we represent Hillside Building LLC. The focus of this case is duty and foreseeability and notice, as my co-counsel was just speaking about, and Judge Bilber, you've asked several questions about. This is a situation where appellant asks this court to attribute knowledge of a specific risk to Hillside, a property owner, based on an off-site random act of violence that is committed against an employee of a tenant. I mean, we're talking about several different layers of kind of removal from the actual situation that occurs at the property, which is the conduit operating the call center that it operates there at Hillside. And so it's too big a jump from a foreseeability standpoint to attribute that knowledge to Hillside. It's too big a jump to attribute it to Conduit, and certainly, it takes another step to get to Hillside. The appellant has laid out a very, very gripping story, portrayal of the facts, and the one piece of that that's missing is that it ignores the fact that Hillside had no knowledge of any of the actions that had happened leading up to this. It had no knowledge of Gibson's propensity to commit crimes, his background as a felon, the kidnapping of Dawkins or her son.
Well, at least for summary judgment purposes, right, we've got to believe that Dawkins told Roe that she was kidnapped. Is that knowledge imputed onto Hillside? Does Hillside know that once Roe is told that?
No, Your Honor, I don't believe that there is this idea that Hillside knows everything that Conduit knows, that a landlord knows everything that his tenant knows. I don't believe the cases necessarily support that, and as we've discussed previously here today, the testimony about Roe's discussion with Dawkins, Dawkins is very, very clear that she does not provide any specifics about the initial incident that happened at the daycare. And so, we still deal with the situation where Roe does not have enough information to foresee an issue occurring at the property, and certainly doesn't, certainly Hillside also does not have any such duty or notice. One of the things that has also been discussed in the briefing is that had there been some security measure been taken, had there been a security guard, had there been someone at the facility who they could contact, that this wouldn't have happened, that this incident could have somehow been prevented. That argument ignores the fact that this happened in the middle of the day in a business park, and it is a large piece of property. You would need tens of security guards to ensure that you caught every potential issue that was going on at the property. Having one person sort of at this property would not have prevented what happened. We also have some testimony that's very interesting on that issue, which is that there are two employees who see Gibson in the parking lot, and they see him go up to Ms. Thompson's vehicle and they see the discussion that happens between the two of them. They see Thompson slide over into the passenger seat, and they see Gibson get into the car and drive away. And nobody thinks enough of Gibson, as a threatening person, or a threat to anyone there in the parking lot, to stop him, to check and see if Ms. Thompson's doing okay, to call the police, to let the property management know, to let Conduit know. That none of that happens. You also have Mr. Moore, who testified that he saw Mr. Gibson at a local food truck that sits there on the property earlier that morning, and he now knows that he's out of place, but he did not think, wow, this person is suspicious and is causing some sort of problem. And so there is this idea that a security guard or some sort of security measure is going to stop this from happening, and that's just not the case. It's a random act of violence committed by someone who is clearly dead set on doing what they're going to do.
Since Hillside controlled the parking lot, does Hillside have a greater duty to Thompson than Conduit does?
No, Your Honor. We believe there's joint control. The lease speaks to the security issue at the property, and while we do have some maintenance measures that are in place there in the parking lot, the lease is very, very clear that there's not going to be security provided by the landlord, by Hillside there. And so the duty for Hillside in this situation is to protect tenants or their employees or invitees from foreseeable incidents, from foreseeable risks. And that ultimately, and that gets back to the question that you asked my co-counsel earlier regarding the foreseeability issue and kind of who has the duty, who has whether this is a premises liability or a general negligence case. It really doesn't matter in this particular instance. There is a situation here where there's no foreseeability, so we can't really ever even get to that sort of next step. We've also talked we've talked at length about the property there, but there is evidence in the record, and it was before the trial court, that this is a no crime or low crime area. There's certainly no history of any violent actions out there. There's no history of kidnappings, murders, knife, gun violence, anything like that. And when looking at the foreseeability and the notice to a landlord or to a tenant, you do have to look at that entire picture. Right? It's not just necessarily one issue. It's an entire picture. There's no residences in really any close proximity to the property. There's not an issue of domestic violence sort of spewing out onto this piece of property. This all happened in the middle of the day with people around, people standing outside, other employees having lunch there at the premises. And so Gibson had also been to the property previously, which appellant points out multiple times in the briefing, and there was no problem, right? He had come to the property, I think it says on 7 or 8 instances prior. He hadn't ever kidnapped anyone from the property. He hadn't ever pulled a knife on anyone at the property. There's this history of him interacting with the property and the people there in a peaceful and normal manner. And then finally, my co-counsel touched on it, but the fact that an off-site incident occurred is not enough of a triggering event to put a landlord or a tenant on notice of a potential risk of an incident that may happen on the premises. The two are completely unrelated, and I know that the briefing appellant points out that both involved a knife, and that the first incident happened at I think it says business-related property, and talks about the daycare as a business-related property because Ms. Dawkins must take her child there so that she can go to work. It's very clearly two completely different pieces of property. It's very clearly two different purposes of those two businesses. And then there's some discussion in the in the initial brief that that there was a departure from what should have been done by the trial court, in that the appellees did not refute every single argument that was made at the lower court level in the complaint. It didn't deal with issues of policies or other things that may have been pled in the complaint. It's not the duty, or it's not the job of a moving party in a summary judgment motion to refute every single fact that has been pled by, or sorry, the allegation that has been pled in the complaint. It is the job to look at the evidence, to present the evidence to the court, and for the court to identify whether or not there is a triable issue. And here we believe that was very, very clearly supported. There was some discussion during appellant's initial argument that Hillside should have had signage or should have had some presence on the property. There's very, very clear testimony from Tel Aviv Bonnaroo at record site 596 that there is a clear line of communication between Conduent and Hillside, that they had interactions before about issues at the property, and that if she had an issue, she certainly could report that. It's also backed by an affidavit that we filed in support of our motion for summary judgment. And so for those reasons, we ask that the court affirm the trial court's decision. So thank you.
Thank you, counsel.
All right. I'm going to start with the Hillside real quick first. Several things. First of all, the duty on summary judgment. Of course, if you're going to use the rule and move for summary judgment, and you're seeking final summary judgment, you got to demonstrate to the trial court as your initial burden that there's no theory that was pled in the complaint under which you could win. And what we were saying is that they only addressed really a portion of the theories that were addressed in the complaint, but not all of the issues. And that's the argument that we were making, that they really, at best, they could be entitled to partial summary judgment, not final summary judgment, because there were other potential ways that we could get to duty and liability that simply were not addressed at the summary judgment stage. Regarding the property itself, the evidence shows that there's a hotel next door, that it's right by I-10. So in the complaint, we allege those issues, that there are several things about the property itself that could make it a potential target of a crime of opportunity by a transient. Somebody staying in a hotel nearby, somebody driving by I-10 and seeing a beautiful building, and let's go take a look and see if we can break into some cars. There's
That would support more of a theory of a general obligation always to have security, as opposed to a specific domestic violence related situational
correct,
issue.
which is something that we did plead. It's actually in the complaint that we did allege that. So the comment about the fact that you would need 10 security guards to protect the property, that really goes into the whole issue of breach. I mean, obviously, if there's a duty, we're not here to establish whether the defendants are liable. We're only asking you to decide here today, that's your looking at the issue de novo, it's just whether the courthouse door should be open to the estate of Elisa Thompson. And of course, as the case goes to trial, they can prove that there's no proximate causation, that there was no breach of the duty, that there was nothing they could have done, that whatever was in place was already reasonable. I would say that at a very minimum, there would be a duty to warn. And the case that she couldn't find, I actually think supports our position. And we do agree that, and maybe I misspoke, so I want to make sure I'm clear on this issue. We're not saying that the manager, Rowe, had to investigate the crime. We're not saying that. We're saying that Ms. Rowe received enough information from Shaterika Dawkins to know that there's a potential danger that could come onto the property. Ms. Dawkins told her, I'm scared, I'm in hiding. She says, I've been threatened. She says in the testimony on the record in her deposition, when questioned for more details, she was probably reluctant, didn't want to talk about the rape and all this stuff too much. But she did say, look, I gave her enough information for her to know what was going on between me and my son and Mr. Reginald Gibson. So all I'm saying, if you look at this case, it's TW and KW versus Regal Trace Limited. That's the case that she couldn't find. And it does say that there's no duty to investigate further, and we agree 100% with that. But it does say, in that particular case, it talks about the fact that the notice that was received by the landlord wasn't very, very specific. And one of the arguments from the defendant was, well, we really didn't have enough information. And what the court said in there is that they had enough information to know that there was a potential danger, and now they had a duty to notify other tenants about this general potential danger. They didn't have to investigate who was the person who was molesting children. They didn't have to do become a law enforcement agency. But once they received information that raises the possibility of a potential danger coming to the property, then they have a duty to, at a minimum, to warn other tenants. It would be the same here. I'm sure that if any of the law clerks came to all of you, to any of you, and say, hey, listen, I'm being stalked, I'm being harassed, and I'm worried, obviously in this particular case, there's not going to be a crime of opportunity happening here because we have security all over the place. We have cameras outside, we have guards in the entrance. So this would not be a place where that could be an issue. But if you go and you have a law clerk in a law firm that goes to the partner and says, oh, you know what, my boyfriend started to stalk me and I'm really scared and all this stuff, I'm in hiding, but I have to come here to earn my living. Now, does this partner have to at least notify everybody else? Hey, maybe you should bring your gun tomorrow to work, this week. There's a guy who's been harassing this young girl, and he could come on the property, and who knows what's going to happen. And I think that if one person, especially a manager, knows about a potential issue, even if it happened off property, right? But why does the form for when you go and you seek a domestic violence injunction, why does it say, one of the places is on the form, you don't have to add it specifically or request it, it's on the form, is that the person against whom the injunction is going to be entered cannot come anywhere close to the place of employment, because that's what harassers, stalkers do. They're trying to attack a target, and one of the places they can easily find them is where they work, where they have to go to earn a living to support themselves. So that's pretty foreseeable, I would say. And obviously, I think opposing counsel misspoke. It was obviously not a random act of violence against Shaterica Dawkins. It's a very targeted attack. What ultimately happened to my client's daughter was a random act in the sense that they had no relationship. There's no evidence that there was a relationship and that she was this target. The target was Shaterica Dawkins. And in fact, the reason why she was kidnapped, her car was taken, was because Reginald Gibson could use Shaterica Dawkins' possessions to try to get contact with Shaterica Dawkins, something that is also predictable. I mean, of course, we all want to think the best of human beings, but I actually cite.
Thank you, Mr. Warshevsky. You're deep into your deep overtime.
10 seconds?
And so 10 seconds.
I'll say, just look, there's a case I cite, I think it's from North Carolina, where there was a horrific incident where a person was stalking an ex-wife and went to look for her at the work, and in the end, several people got killed in the parking lot outside, and inside the property, luckily she was in a locked area and was not killed, but it happens. Unfortunately, it happens. Thank you.
Thank you. Thank you, counsel, and we are adjourned.